Welcome, everyone. Thank you for joining us today. We're talking today about ERISA legal compliance and hot topics for in-house counsel. I am Malika Terry. I'm a total rewards professional, and I've been working in the Atlanta area for about 15 years with various different types of compensation and benefits programs. And I am joined today by Ann Tyler and Charlene Barnwell.
My name is Ann Tyler Hall. I am the owner and principal at Hall Benefits Law. It's an ERISA law firm, and we specialize in retirement plans, health and welfare benefits, executive compensation, ESOPs, and ERISA litigation. And I started out my career in 2007 at Alston & Bird and then King & Spalding.
Thank you. I'm Charlene Barnwell. I'm a senior ERISA compliance consultant or counsel at the Hall Benefits Law. I've been practicing law since 2000 as an ERISA in-house counsel for a governmental entity. And Ann and I, we work together at Hall Benefits Law.
Well, thank you, Ann and Charlene. We're going to start off today by talking a little bit about health and welfare plans and the importance of having ERISA counsel as a part of that program. So I'm going to kick it off with maybe just what are some of the big health and welfare benefit legal compliance issues that your clients are facing?
Absolutely. Thanks, Malika. So one of the big areas that we help our plan sponsor clients with is HIPAA, Health Insurance Portability and Accountability Act, otherwise known as HIPAA compliance. And specifically, we help plan sponsors or employers with setting up a paradigm for compliance with the HIPAA requirements, which can be broad and deep. And so a couple of different things that we do for our in-house counsel that we work with are developing HIPAA policies and procedures, conducting ongoing annual HIPAA training because the laws are constantly changing, reviewing the HIPAA notice of privacy practices. These are all key components of a HIPAA legal compliance paradigm. And this is important because the HIPAA rules were updated in 2013 through the HITECH Act, but depending upon the severity of the penalty, they actually have 4 different tiers of penalties, but the penalties now go up to $1.5 million for each breach or incident. So that can be devastating for a company. So we want to make sure that our employer clients are well prepared for HIPAA compliance, and HIPAA basically governs the rules around handling protected health information. Yes. So someone's social security, date of birth, which plan they're in. And so the government wants employers to be very careful with that information, guard and protect that information. So we help plan sponsors with the HIPAA compliance. I'll also mention one of the things we've been busy with lately are business associate agreements. Mm-hmm. And so if you are an employer or a health plan for an employer, which is considered a covered entity, and you engage a service provider to handle PHI or to handle anything dealing with your plan participants and their protected health information, then you need to have a business associate agreement in place. And I'm going to let Charlene talk more specifically about a matter that we worked on recently and some of the specific issues that we addressed and dealt with for that client.
Sure. So Ann, as Ann spoke about, yes, HIPAA compliance is extremely important. We've dealt with HIPAA compliance with an international company covered entity that worked with a business associate that's also international. Mm-hmm. More specifically was the HIPAA business associate agreement. There were quite a few issues that we reviewed in that agreement, but most importantly, it was the indemnification provision. Normally, the business associate would not include an indemnification, mm-hmm. but for this particular covered entity that was our client, they conceded to have that in the agreement, the business associate agreement. One of the thorny issues that was discussed was around ordinary and gross negligence, and that mainly being that from a gross negligence perspective, a total disregard of the use and need of using reasonable care mm-hmm. when handling, to Ann's point, protected health information. We were going back and forth with that business associate. There were a couple of issues that we did discuss within that indemnification, like willful misconduct, misrepresentation, willful misconduct as far as warranties of their the way that they handle their security technologies. But because of the time sensitivity and that we needed to move forward with the actual service, we had to table some of those issues. But most importantly, we were able to resolve the ordinary and gross negligence issue that we had with that particular entity. But that was one area that was very thorny, but we were able to table most of them because we have other business associates that were dealing with the same or similar issues with the covered entity as well.
And I would just say, in our experience, we have had plan sponsors with very kind of bare bones business associate agreements. And when a breach occurs, I mean, we've had a client that had a breach and did not have a robust business associate agreement, and so they had to take on all the cost of fixing the issue. And that's why business associate agreements, HIPAA business associate agreements, are so important.
Well, how as a plan sponsor do we know to actually start the process of partnering with ERISA Counsel when we're looking at different aspects of our health and welfare programs?
If you have protected health information, which is really the HHS, Department of Health and Human Services, defines as if you have someone's date of birth and the plan that they're in, that could be protected health information. And if you are dealing with protected health information on any type of regular basis, and by regular I mean maybe just annually, maybe annually you're sending it to your broker, your business associate, whomever, you need to have policies and procedures in place, because it doesn't necessarily, a PHI breach doesn't just occur with very large companies. You know, you could have 50 employees, and we've used the example in HIPAA training where you have 2 Amy's in your email system and you send the information to the wrong Amy. That's a breach. And so anyone that has a health plan and retains and obtains protected health information should have HIPAA policies and procedures in place and a paradigm for compliance with HIPAA.
So it sounds like to me, Ann, that any employer or plan sponsor, because technically we are plan sponsors if we're the employer and we offer health and welfare programs, that any employer, regardless if you're a small employer all the way up to a large employer, you should be working with your ERISA counsel so that you can ensure that you're protecting information that we provide to outside entities, which could be your medical carriers, they could be your disability carriers, any of those individuals, we need to be protecting ourselves. So we need to partner with ERISA attorneys, whether those are in-house attorneys or other attorneys that we work with. It sounds like that's very important so that we can mitigate our risks and also, you know, maybe eliminate any type of fines or fees that we may encounter.
Absolutely.
Okay, thank you.
Yeah, I would say, Malika, the rules for employers once they hit the 50 mark are more robust, and the penalties. But if you're getting close to that 50 employee mark, you need to start thinking about it. And it's just a best practice to have these in place anyway.
Okay, well, thank you.
And then the other issue that we're dealing with, and that has been a real hot topic, as I'm sure we've all dealt with, the Affordable Care Act.
Yes.
And so in health and welfare benefits, we also help our clients with health care reform, navigating health care reform. Since 2010, that's been a hot topic. And then this year, and actually we got our first client, it's called an IRS Letter 226J. It's a penalty letter. It is based on the employer pay-or-play rules and the penalties associated with the employer pay-or-play. And so those started coming out. We got our first one in December from a client. And so the IRS issues these letters when they believe that an employer did not offer ACA-compliant health coverage to what is deemed as substantially all of their full-time employees. And so the first letter that we got from a client was a 6-figure penalty, and we worked towards abatement. As of now, we've helped clients through this year, just through this year, September of this year, have helped clients abate over $2 million in these penalties. So we're excited about that. But I think it's important if you get an IRS letter 226J, and this is for the 2015 year, we expect that they're going to be coming for 2016, 17, 18. And so one of the things when we finish with a client is we talk about, let's look at your 2016 Affordable Care Act reporting to try to mitigate this type of issue recurring. But if you get an IRS letter 226J, our best recommendation is not to try to go that alone. We've had very good success, but we put together a robust defense, a dispute letter, and again, we've had great success, over $2 million in penalty abatements this year. I'll give one example as well. You know, we had a plan sponsor client that was using a third-party administrator, and they got a letter from the IRS saying, we think that you're an applicable large employer and could be subject to the pay or play penalty. And the plan sponsor, this employer's position was, well, our third-party administrator is handling this. And you just have to be careful as in-house counsel or as an employer plan sponsor that firstly that you read the service agreements of your third-party administrators and third-party service providers, because very often they put in their agreements the indemnification provisions that we like to put in. We understand because we like to put those indemnification provisions in the agreements for our clients. But often they do not accept any legal compliance responsibility. So that's the first item. The second is that the IRS, the Department of Labor, HHS, their jurisdiction is over the employer, the plan sponsor. So it's very difficult for them to, even if it was the third-party administrator's fault or the third-party service provider's was culpable, it is very difficult for those governmental agencies to assess any type of fine or penalty. It usually goes on the employer. So those are some experiential situations that we've been in with the 226J.
And another example, if you don't mind me giving another example, Ann, we with a client of ours that had a TPA arrangement, certainly we received a 226J letter. This client was a restaurant supply chain that it's located in multiple states in the U.S. So when you look at a 1094C, which is an employer reporting file, annual reporting, it will indicate that employer has an affiliated with other entities within that main parent company. So when we reviewed the 1094C, which was the employer reporting, and also their employee reporting, the 1095Cs, we did notice some issues which caused the IRS and DOL some concerns. But after we reviewed the 1094s and employer records, we realized that it was a mistake, an honest mistake. And typically for 2015, the DOL would, in my understanding, would kind of give a slap on the hand, right? But unfortunately, this was the TPA that actually drafted these documents. And again, to Ann's point, I mean, it is the duty of the plan sponsor to monitor, mainly before monitoring, to review all documents provided, monitor the progress as they go along before it's actually submitted. So in this situation, unfortunately, we did review, we saw some mistakes. We drafted a response to the IRS. This was an $80,000 penalty assessment, but we were fortunate enough that we ended up getting it abated. But this particular restaurant supply chain also had other affiliated entities. So when you think about affiliated service group or entities, there's that control group and that affiliated service group analysis that we have to take. And so one of the things that we talked about was, look, if you have one employer with other affiliated service groups attached to this particular parent company, that's considered, for health plan purposes under ACA, one plan, one employer. So we had to, counsel our client to say, you may want to look at your other entities to make sure that they are actually doing the same reporting, or may not receive what's called an employee at that particular company location received a premium tax credit. So that exercise was done by the client. The client didn't want to go and do anything further. They relied on our response. Again, we didn't receive an abatement. But again, really the issue is go back and look at your records, review your affiliated service groups, attach yourself and engage yourself with an ERISA compliance counsel to make sure that you are that you're approving and reviewing these 1094s and 1095s, that you understand what you're approving with your TPA, and monitor the process as it goes along. So that's a really good example with regards to working well with your outside counsel.
Yeah, and I would just say to follow up with what you said, Charlene, we have had employers who come to us and say, well, we only have 40 employees at our company. But then we do a control group, affiliated service group analysis, and for purposes of, and this applies for purposes of the Affordable Care Act, and it also applies for purposes of retirement plans. The IRS, if you are part of a control group, and that's based on ownership, so if you have the threshold common ownership between entities, or it also looks at function, and that's the affiliated service group rules. And if you meet those thresholds between entities, then you are considered one employer. So we had this employer that said, well, we only have 40 employees, but they were part of a control group, and the second company B had 50 employees, and when you aggregated them, they were over the 50 employee applicable large employer threshold, and were thereby subject to the Affordable Care Act.
Yes. Yes. So it sounds like to me it's really in the best interest of employers, plan sponsors, to make sure that we are partnering with ERISA Counsel. Absolutely. And also ensuring that if you're not a large company with more than 1,000 employees and you have a larger budget and you might be able to have someone in-house, you do the partnership, but even if you have that in-house expertise, you still may want to partner with someone to maybe review some of your health and welfare reporting and plans on an ongoing basis, maybe once or twice a year, to kind of have that double check or that second set of eyes on that plan.
Absolutely.
Okay.
And we work both ways, Malika.
Okay.
We sometimes with the smaller or middle market companies, they don't have in-house ERISA counsel. And so they're outside in-house counsel. And then with other larger companies that we work with, they have counsel and we collaborate with them.
Absolutely. The key is being proactive and not reactive.
Absolutely.
And kind of think through, kind of forecast what's going to happen before it actually happens.
Okay. And then with outside counsel, you're staying on the cutting edge of what's happening, especially with health and welfare, and that it actually changes consistently or constantly is changing. So you're staying abreast of what's going on, whereas your in-house counsel may be a jack of all trades, and they're doing a little bit of everything. So they may be able to assist you with your third-party administrator contracts. However, they may not be a direct ERISA attorney, and therefore partnering with someone like your firm gives you that opportunity to have that second set of eyes on your health and welfare plan.
That's absolutely right.
Okay, well, thank you very much. Well, now I know that we want to move from talking about health and welfare benefit programs over to talking a little bit about retirement programs and some of the responsibilities that we have there, both as plan sponsors / employers, and then also what you offer to plan sponsors. So, do you want to tell me a little bit, Charlene and Ann, about what are some of the most significant things that employers should be thinking about when it comes to retirement plans now?
Absolutely. So one of the things we've really focused on at Hall Benefits Law is a fiduciary legal compliance paradigm. And so if you are making any type of decision as it pertains to your company's retirement plan, or if you advise your in-house counsel and you know of, are part of the group that makes important decisions as it relates to plan assets, plan administration. If you have any discretionary authority over a retirement plan assets or administration, then you are an ERISA fiduciary. What does this mean? So there's a provision in ERISA that provides if there are losses to the plan and there's found to be a fiduciary breach, you as an ERISA fiduciary can be held personally liable for the losses to the plan. So one of the foundational things, we always help clients with operational compliance issues, and there are a lot of different moving parts, compensation, loans, hardship withdrawals in a plan. We're always happy to and do a lot of voluntary correction programs throughout the year through the EPCRS program, Employee Plans Compliance Resolution System. But where we like to start is fiduciary legal compliance and fiduciaries understanding who they are and what their responsibilities are to the plan. And so one of the things that we've developed at Hall Benefits Law is this fiduciary legal compliance review. It's a monthly program. It's a fee-based monthly program. And the majority of the expenses can be paid for from plan assets, reasonable plan expense. And so as part of this program, I'll just delineate a few of the things that we do. Establish, work with the plan sponsor to establish a fiduciary committee, and then develop a fiduciary committee charter, which is the roadmap for what the committee is and their composition and what their responsibilities and roles, ongoing functions are. Then we look at fiduciary liability insurance. So there's a difference. There's a fidelity bond, which protects the plan against losses, and then there's fiduciary liability insurance, which is for the individual, to protect the individual if they're in a fiduciary breach lawsuit or situation. And so we look at the fiduciary liability insurance, and Charlene and I will talk about a specific example a little later. We also attend the fiduciary committee meetings and review the meeting minutes. Because there have been some recent cases that have shown that the plan sponsor memorialized what they had, the actions that they had taken, and then the judge or the court actually used those minutes to indict them of fiduciary breach. So you always want those meeting minutes to be a protection, a safeguard, not to create more exposure for you as the plan sponsor. So we review those meeting minutes to make sure that there are no red flags, no issues that would be picked out as potentially being fiduciary breach issue. We also look at the investment policy statement. This is usually if you have an advisor on your plan, you should have an investment policy that is a roadmap for how you're going to invest the plan assets. And we have general guidance and ideas around what the investment policy statement should say and should not say. And then we look at the service provider agreements that we alluded to earlier. But it's very important for a plan to have a good fiduciary legal compliance paradigm. To then avoid the operational compliance issues, to firstly understand what the fiduciary's responsibilities are and avoid any type of fiduciary breach or a situation like that, but then also to avoid the operational compliance issues.
Now, when you go in to talk with employers or plan sponsors about setting up all of these different types of roles and this responsibility that they have, how often are you finding that some of these items are already in place? Like, do most companies that you end up engaging with, do they already have their investment policy statement written and maybe have done some fiduciary responsibility training with the actual investment committee or retirement committee? Are you finding some of that already, or are you really starting from scratch with a lot of companies?
Great question. Both. Okay. So some of the companies, we'll come in and look at their paradigm, and they just don't have one, right? So we're starting from scratch and building out the committee and the committee charter. Other companies will have, for instance, a committee charter, an investment policy statement, or fiduciary liability insurance. And we'll talk about this. We recently helped a client that had fiduciary liability insurance coverage, and we dug in, looked at the policy. And firstly, there was what is called a deteriorating defense clause. Okay. So they had, $1 million of coverage, but any costs that were to be spent on their defense would be subtracted from that coverage. Okay. And the average cost to defend a fiduciary breach lawsuit, just to get it to motion to dismiss stage, study last year, end of last year release, $500,000, $500,000 average. If you're involved, you're an employer, you're involved in a fiduciary breach lawsuit, go ahead and kind of set aside your by $500,000, and that's on the low end. So $1 million of coverage really was $500,000 of coverage. So we had that discussion. I'll let Charlene also talk about some of the issues that she reviewed.
Right, and the other issues, including the deteriorating defense clause, was the opportunity for our client to select their own counsel to defend the case. Certainly, the insurer said, "Well, yeah, we will select our own counsel, and we will select the counsel for you." What we did, we went back and negotiated. There was something in the clause that stated, "Well, you have an opportunity," with a caveat, but at the end of the day, we ended up recommending to make some modifications. We added where the client could select their own counsel within 60 days in writing to assume their own defense. Another issue was that we did, the actual fiduciary liability insurance did not protect against any audit penalties and claims. So there were some auditing reports and reporting different reports and documents that were probably protected under the coverage amount. But as far as protecting them against any audit penalties and refines from a DOL or IRS audit, there was no protection, so we made some modifications on that as well. Okay. Another client, speaking of fiduciary legal compliance review, we did review a nursing home service provider agreement, fairly new 401k plan. There were a couple of issues, not only the service agreement, but we also looked at their 401k documents. They had a volume submitter with an adoption agreement, which is, as you well know, an SPD, and that's commonly known. Few issues that came about with the 401k documents were like loans and hardship withdrawals, and certainly the safe harbor match opportunity, match contributions. But the thorny issue that we dealt with this nursing home that had, in this case, is 3 locations in the Atlanta area, were about the security provisions. That was one. And then the second was really with regards to indemnification, which we resolved pretty quickly. The actual provider accepted all the mutual indemnification opportunities. So that was great. We removed the gross negligence and willful misconduct. But again, the security provisions, because you're looking at information, not protected information, but security information with regards to employees' name, date of birth, date of term. It's electronic financial information that's being transmitted between plan sponsor and the record keeper, and having security provisions in place that's strong where the employee can actually be able to either have time to review, that was key. And so in this particular situation here, it was a lot of back and forth of transmitting reports, and the record keeper was willing to accept either not removing the immediate review from the plan sponsor to review documents to giving the plan sponsor between 5 to 10 days to review. Because in this case, again, as a fiduciary, the plan sponsor needed some time to either consult with outside counsel on various reports and documents, and having an immediate clause in that security provision was not going to be reasonable for them at the time.
Okay. So it sounds like partnering with your ERISA attorney will actually help you to even avoid potential fines and issues, and to continually educate your retirement committee, your investment committee on some of their duties and responsibilities.
Absolutely. And I would just raise one of the issues that we're working on right now for a client was they failed to timely file their annual report. They had, we see this a lot in companies that are acquiring companies. They had a short plan year and failed to timely file their Form 5500, that's what it's known as in the ERISA world, with an auditor's report. And the Department of Labor assessed them a $50,000 penalty, and they've gotten 2 of those letters. So there's just a litany of other issues. We've focused on fiduciary legal compliance and a few specific topics, service provider agreements, but there are a litany of other issues. Again, it highlights why it's so important to have ERISA counsel on call.
And then when things change, as we know with some of the new tax regulations, there were some changes that impacted your 401k programs. And partnering with your ERISA attorney, you can also provide us as plan sponsors and as employers information about how to make those updates, whether those updates need to be made to practices and ensured within our actual administrators and ensuring that they're carrying out their duties appropriately, or if we need to make changes to our actual plan documents. Those types of things, when they happen and occur, we can partner with our ERISA attorneys to ensure that we are making sure that that is moved throughout our process appropriately too.
And we'll talk more about that later as to how we can better, really support the in-house counsel. But the one thing from my experience as, when I first started as an attorney, I started in-house. I learned that, you really need to really understand and kind of grasp to the in-house counsel, the outside counsel that really knows and have that creativity, that expertise in that area. So that's, I think to your point, Malika, that is key.
Okay.
That is key.
All right. So I know that retirement plans are a big piece also, but what about executive compensation? I know that a lot of our retirement programs, we have a lot of our high-level employees that are in there, those that would be a part of our executive compensation groups. What about when it comes to executive compensation? What are some of the big or key topics right now in executive compensation that we as plan sponsors and employers should be working with our ERISA attorneys on?
Absolutely. I think executive compensation is critical, and getting that, being contemplative about a robust program to attract and retain your top employees. We're in a very fluid job market right now, and people are mobile, and so you want to make sure that you have a program in place that identifies what are the key components that you want to grow in your company, and then incents your key employees in the right way. And so we do a lot of executive compensation, and this time of year, third and fourth quarter is a big time of the year when employers start thinking about their executive compensation program. But again, it is so critical to have a thoughtful, compliant executive compensation program that is focused on attracting and retaining top employees. And on the flip side, not having a thoughtful program that incents the right performance and the right behavior. We read study after study where it costs companies, millions in dollars and in growth.
Yes.
So that's a big part of our practice and how we help companies. And I'll let Charlene talk about specifically diving into executive compensation design.
Sure. So speaking of recruiting and retaining talent, a lot of things to Ann's point in knowing who your talent population, your talent pool is knowing your population, your demographics once they're actually in-house with you. And so some of the things that we try to impose on our in-house counsel is understand how do you incent these employees, right? Key employees. For example, company performance. Is it company performance? Is it individual performance, or is it loyalty to the company? It may be all three, depending on the company's strategy, overall goal, and objectives for that plan year. So those three things, maybe all or maybe one, depending on the strategy for that company, are critical to contemplate up front when you're actually looking at your plan design, your executive plan design. Another thing to consider is different alternatives to an executive comp plan, such as a non-qualified deferred compensation plan, restricted stock, phantom stock, stock appreciation rights, capital interest, and profit interest. I won't take too much time to kind of go through all of them, but the gist of those alternative plans are really about, for example, a phantom stock basically is future, not necessarily, it can be cash, but it's something that it's a value on the company's value of company's share, where stock appreciation is, that's where there may be some concerns from the employer standpoint because there's a solution of their own ownership interests. So there are tax implications that are involved. There are administrative implications because you need to have, depending on what type of plan cash on hand. Funding obligations are also something to consider when you're looking at these different alternative executive comp plans.
And from an employer perspective, you really need to focus on what is going on in your business and how you want to drive long-term performance over the next 3 to 5 years. Because when you look at executive compensation, outside of base pay, really executive compensation should drive long-term results and not just your short-term results. And also with some of the vehicles that you mentioned, being a person who's worked for both publicly traded and privately held companies, I think we forget sometimes that even in the privately held companies, it's important to have those executive comp components. And you can actually work with an ERISA attorney to actually develop components of an executive comp plan for a privately held company that mimics a restricted stock program or mimics a stock appreciation rights program, because you do still want to attract, retain, and develop that high quality talent even in that privately held company.
I think a great example of a client that had worked with a law firm previously, and the law firm had put in place a deferred compensation program pretty quickly, had given them some advice and said, okay, here's what we're going to do. And after about 3 years, that company, about a 400-person firm, came to us and said, this isn't working. This is not working for us. It's not driving company performance. It's not driving individual performance. We've got to break it down and redesign it. And so that, I think, highlights a couple of things. Working with ERISA Counsel that is your partner and how important that is. That isn't just giving you, here's what you should do, or let's get this done as quickly as possible, but is contemplative and partnering and trying to understand your business and how to grow, how to help your business grow through this executive compensation program. And then secondly, how important it is to be contemplative when you're designing an executive compensation program, and really thinking about where have we been, where are we now, and where do we want to go, and what would incent our employees. Getting a sense of, for some employees, they want stock, so a stock appreciation right, or they want an actual tangible stock certificate and a feeling of ownership in the company, and so phantom stock may not incent them. And so we try to stop and have those types of discussions, because we'll have employers come to us and say, well, I was out golfing with my friend and their company's doing this. Leadership tend to flock together in companies, and so they'll come to us and say, well, we want to do this program. And we'll ask them to just pause with us and walk through their company details and specifics and their employees and what drives their employees to really get a good, comprehensive, long-term program. Because you could put an executive compensation program in, and it can look great for a year or two, like our client, and then in 2 or 3 years, it's just not driving the performance. So I would say that outside our in-house counsel with companies need to be interviewing ERISA counsel to determine how do you work with employers to design executive compensation programs. And they should be listening for key things such as partnering, creativity, really thinking through plan design and thinking about long-term objectives. And your ERISA counsel should be asking those questions of you if you are in-house counsel. And so the takeaway too from this example was that we had to, the unique part of an executive compensation program is different from retirement plans and health and welfare plans. There's a separate body of law under the Internal Revenue Code that was passed in 2007, became effective in 2007, and it's known as Code Section 409A. And so when we start to talk about a program that was already put in place and that was absolutely subject to Code Section 409A, one of the unique challenges that we had with this employer was deconstructing their current program and being mindful of the boundaries that Code Section 409A put on that, and then rebuilding a program over that. And so again, ERISA Counsel keywords, before you're working with them, they should be partnering, they should be talking about long-term solutions, and they should be talking about creativity, specifically with respect to, for instance, in an executive compensation program, who's going to be eligible? Yes. What are the awards going to look like? Is this going to be stock, or is it going to be just a phantom or an appreciation right? Vesting, how long do you want to require these employees to be with the company? We call those the golden handcuffs,
Yes.
right? So,
and sometimes you want to uncuff people. And I've worked with an employer in the past where we were in a manufacturing industry, and there were a lot of employees who had been with the company for years. And they were reluctant to retire because some of them had these executive compensation programs and plans where they would vest in the future, and they didn't want to leave that vesting opportunity. So we became creative with our ERISA attorney, and we talked about creating new programs that we could use different triggers in there. So if it does have a vesting, maybe we look at allowing it to continue to vest while you're in retirement. So that type of creative thinking allowed us to say, hey, yes, you've reached retirement eligibility age, and when you leave the company, you don't just get cut off from this particular executive comp program. It actually will continue to vest throughout your retirement, and you'll get paid out at the same time as everyone else. So that actually helped with this particular employer because we wanted people to start considering retirement so that we can bring in more individuals into the company to fill those shoes. And this gave those executives the comfort in knowing that they could retire and still get that full award. So yes, being creative and working with your ERISA attorney is very important around executive compensation, but as we've discussed today, it's really important around all aspects of our total rewards program. So as total rewards professionals, it's important for us to connect with our ERISA attorneys, for us to make sure that we're partnering with them because we're the subject matter expert when it comes to the actual plans and programs. However, these individuals are the subject matter experts when it comes to making sure that we're compliant with those programs, that we're not getting fines and we're avoiding that, and that we're also educating our executives and educating our employees about those programs.
Malika, I would piggyback off of what you said. I think that highlights exactly what we're talking about, is that these decisions that you make with respect to plan design absolutely drive and incent behavior. And you want to think about what behavior you want to incent. So, it sounds like they had individuals that were hanging on because there was a long vesting schedule, and then that became an issue because then they wouldn't retire, yes. Right? And we've had a similar, a little bit different situation, but with respect to vesting, we had a plan sponsor who said, I want to put a 10-year vesting schedule, which is a fairly lengthy, in the ERISA world, that's a lengthy vesting schedule. And we recommended kind of an informal poll, and the employees basically said, after about 5 years, you've lost us. And 10 years just seems like such a long glide path that that just does not incent us. That does not excite us. So that highlights exactly why it's so important to be contemplative and thoughtful about plan design at the onset. And then the other aspect of executive compensation, you alluded to this, is compliance. And because executive compensation, most programs are subject to Code Section 409A, that is something that that is another reason why employers in-house counsel need to be working with ERISA counsel. Right.
So to Ann's point, we talked about the strategy. We talked about ways to incentivize our employees, key employees. Now we're in the point where we need to start drafting the plan documents. And part of that plan document drafting is being aware of Section 409A, which applies to any compensations earned in 1 year and paid in another year. Section 409A governs the timing and payment. What I mean by that, by service recipients and service providers. Service recipients tend to include public companies, companies, nonprofit, and public companies. Service providers include employees, directors, and independent contractors. So when you're drafting these documents under Section 409A, you're looking at written plan requirements. You're looking at distribution restrictions. For example, termination for cause. How do we forfeit this particular benefit for this key employees? Is there a death restriction? Is there a disability restriction? Change in control is another example. What about election restrictions? Is it going to be a schedule of where there's a 5-year period where that person actually obtains that vesting of that benefit? Funding restrictions. Are you going to give them a one-time lump sum payment? So those are a lot of the requirements from a compliance standpoint under Section 409A that you do need to adhere to and really be mindful of. And certainly an ERISA compliance counsel will support that employer as they work through their drafting of their plan documents.
Okay. And the bite on the Code Section 409A is if you have a plan that is not compliant with 409A, then the executive is then taxed. So the executive is taxed federal tax, state tax, and then there's a 20% excise tax on top of that, plus interest.
So you could end up with an unhappy employee if you, as a plan sponsor, make a mistake with the 409A.
Absolutely right. And so we've had these conversations with employers, and it's interesting how those discussions play out because we've heard even other ERISA attorneys say this. Well, if you make a mistake, it really falls on the executive, but that's not a place you want to be. That's an HR, PR perspective. And then there are tucked in the Internal Revenue Code, penalties on the employer for failure to properly report a Code Section 409A violation. So the employer does not get off scot-free on this. The employer can be held and be subject to penalties and fines as well. Okay. And so it is important to make sure that your plan has been properly vetted and that it is legally compliant. And we see a lot of employers that either try to go it alone or hire generalists to write the document, or we've even seen some pull it off the internet. And that is not a sound strategy for developing your executive compensation program. So again, and the implication to the executive is, when you add to the federal, state, the excise tax and interest, you could be looking at 60% of the benefit being paid in taxes and penalties. It's not a place you want your executives to be.
No. It will be a very unhappy executive who may not be productive in his or her job.
That's right.
And, with long-term incentive programs and executive comp, there's also for publicly traded companies, there's also implications for your SEC filings and your proxy. So there's a lot to consider when you're looking at the development of your executive comp plans, because it may not only impact you from a perspective of that particular employer or employee, you may actually be impacted by other reporting and filing that you have to do as an employer. So it's really important to be careful when it comes to that area. It's important to have these plans in place and to develop a robust executive compensation program so that you can attract, retain, and motivate your employees. However, you still need to make sure that it's compliant and it's actually driving the right behavior that you want it to drive and not creating more issues. So, okay, well, thank you very much. And I think that really brings us back to where we started and how we started talking about utilizing and working with ERISA Counsel. And as a plan sponsor and an employer, what we should be looking for when we are partnering with ERISA attorneys. So I really want to turn it back over to you guys to say, as an employer, as a plan sponsor, what should I be looking for? Because I need to consider health and welfare, retirement programs, and executive compensation programs. So what should I look for in that partnership with the ERISA attorney?
Absolutely. Our motto has been proactive and relationship driven and partnering with the client. So going back to what we talked about on the executive compensation, you need a ERISA counsel, and you really need to interview your ERISA counsel before you engage and ask them how they work and ask, how do you approach problem solving in complex ERISA issues? And we always try to give our clients, when we come to a compliance issue, we'll say, here's the issue, and there are 3 alternatives. Okay. and to have them engaged in the process and the decision-making process, because ERISA legal compliance is complex, nuanced law. It's ever changing, and we understand as a business ourselves that it's not just a black and white. Well, this is the law, and this is how it should be done. That there are other business practicalities. So we had a phone call this morning with a client that said, "Listen, I understand my exposure, but I'm going to go with a kind of a middle of the road approach because trying to get this completely compliant is just cost prohibitive for us. But you want ERISA legal compliance, legal counsel guiding you through that process." So a typical discussion with a plan sponsor will go like this. We'll talk about the ERISA legal compliance issue, why it's important, what the exposure is, and then we give them 3 options. Here's your first option is, we always say, do nothing. And we never recommend that. Do nothing is obviously the most exposure, and that's not advisable. Then we'll take a middle of the road approach, or give them a middle of the road alternative, and we'll describe this is taking some good faith, proactive measures. It doesn't get you 100% compliant, or it doesn't completely mitigate your exposure, but it mitigates it some, and it's the cost to this is much less than the third option, which is the most conservative, which is the most aggressively addressing the legal compliance issue. And sometimes it depends upon the client's risk tolerance. Sometimes it depends upon their budget as to which alternative they want to take. We always try to get them involved in that decision-making process. And your ERISA counsel really shouldn't be telling you yes or no, black or white. They should be working with you, partnering with you, and saying, okay, here are the issues, and here are some alternatives. We had a plan sponsor about a year ago that had a health and welfare benefits legal compliance issue. And there's no formal correction program for health and welfare plans. There is, however, for retirement plans, EPCRS, the Employee Plans Compliance Resolution System. So this was an employer that was considering going public. And they had a fairly major issue with their health and welfare benefits plan, and they wanted to address it. They wanted to resolve it. They didn't want to have to report it with their auditor or on any other filing. And so we started thinking creatively, our team, creatively about how to tackle this, resolve it, and mitigate their exposure. And so we took the concepts from EPCRS and applied it to this situation and came up with a correction proposal, submitted it to the IRS here in Atlanta. And it was a several month long process. We got it accepted. The plan sponsor paid some taxes and a very nominal penalty. And we reminded the IRS, as we always do, reminded the IRS and the DOL, when we're working with them, that when we're coming forward voluntarily, that our plan sponsor, we expect them to get a better result than if the DOL or the IRS had to catch it on audit. And that usually, I think your ERISA counsel, particularly when you're in a correction situation and you're going forward voluntarily, or you're defending in an audit, needs to be your advocate as well. And so we try to be our client's advocate to get them the best result. And so in this particular situation, the plan sponsor paid what they considered a nominal amount to address the situation, and we got a signed agreement from the IRS that they wouldn't reopen this issue, that it was resolved, and the plan sponsor was thrilled because then they didn't have to report anything, and about 6 months later, they went public.
So let's talk a little bit about some hot topics and hot issues that are actually bubbling up now in health and welfare and retirement plans. Are there anything that maybe some of your clients or some things that you've heard about recently in those 2 areas that are really kind of hitting hard right now?
Yes. So Association Health Plans, President Trump issued an executive order to review and to broaden the rules around health plans and plans being part of the same platform, although the employers are completely unrelated.
Oh, yes.
And so previously what we had were the multiple employer welfare arrangement rules, MEWAs, and they're subject to very stringent legal compliance requirements. And in order to even be a part of a MEWA, the employers and the companies had to have a nexus, a commonality. So they had to be in the same industry. There had to be some other reason than just cost efficiency, health plan costs and cost efficiency. What the new guidance is purporting to do is to allow employers that are completely unrelated to be part of an association health plan and to realize that economy of scale and the cost efficiencies. And you could potentially have employers with 2 employees that are on this platform. It's been interesting because the guidance came out a few months ago, and we haven't seen a whole lot of movement. We partner with a lot of brokers. We work with a lot of health insurance brokers who have clients that need our ERISA legal compliance help. And so we've spoken with a few brokers about the association health plan, and their impression is that the insurers haven't quite bought into this and how it might be profitable for them. So we're still watching this play out, but it certainly is a real broadening and making more flexible what the rules around what we had traditionally considered multiple employer welfare arrangements and all the requirements that if you were going to be part of a multiple employer health plan, that you had to meet all these stipulations and had to have commonalities, and it couldn't just be about health plan cost efficiency. So this is a real shift away from that requirement, a real broadening of the rules.
Yeah. And so, I don't know, with regards to the MEWAs and what Ann was talking about, the multiple employer welfare plans, and now what Trump is putting out there as proposed regulations, some of the concerns may come up from an insolvency potentially, maybe, because you're looking at different employee groups, depending on size, that may have issues from a funding perspective. So those are some of the things that, certainly the legislator are looking at and seeing how they can work around those issues, because that may be probably one of the reasons why the insurers are having some concerns.
Okay. Any other hot topics that maybe we can touch on and let everyone know about?
So on the retirement plan side, President Trump has indicated that he wants more flexibility as it pertains to multiple employer plans on the retirement plan side. And so it's actually probably, I guess, a mirror of the association health plans, but allowing unrelated employers to aggregate and realize cost efficiencies. So for instance, an employer with 10 employees pays relatively more in administrative fees, TPA fees, than a plan or an employer with 400 employees. The total cost, obviously, with 400 versus 10 is more for the 400 person firm. But so the idea is that if you're a 10 person firm and you're on a multiple employer plan or a MEP, that you're realizing some real cost efficiencies. The other thing is that it's shown that small employers, those with less than 50 employees, I believe the stats are somewhere around 40% of employers with less than 50 employees do not offer a retirement plan. And so I was asked the question, well, can't these employers or these employees just invest and put money aside in a traditional IRA? Well, the limit generally for your traditional IRA is about $5,500 a year. And for a 401k plan in 2018, the limit is $18,500. So if you're an employee and you want to be putting away more tax-deferred money, I mean, it's a great alternative and allows you to put $13,000 more away, which quite frankly also ties into what we've seen in many of the benefits reports and benefit studies, is that Many Americans are woefully unprepared for retirement. They don't have enough saved. So I think that this could be a really nice way to allow some of the smaller employers, A, to have cost efficiencies that have generally been enjoyed by the larger employers, and then B, to give their employees a retirement plan option, which is a good thing. The idea of expanding opportunities for employers and thereby their employees to retirement, I think is a good thing.
Yeah, definitely a big step.
Okay. And it sounds like even with both of those hot topics, that one of the big things is really trying to pool resources so that we can get economies of scale, even for those smaller employers, and therefore be able to provide things such as health care at an affordable price, and also retirement programs for your employees, even for the smaller companies. So that sounds great for some of the hot topics and things that are happening right now. So
it sounds great. And so what's going to be interesting is to see how it plays out, because some of the best laid plans don't always work out that way. But and we'll continue to monitor legislation as it comes out and as the rules are finalized and clarified. But the intent and the idea behind some of these changes, I think, are good. It can be good, positive changes for benefits.
Mm-hmm. Positive for the employees and also positive for the employer.
Definitely a win-win situation.
Yes, absolutely. Well, it sounds like, from health and welfare plans, retirement plans, and also executive compensation, one of the big things that we as employers and plan sponsors should think about when we're looking at choosing ERISA counsel or working with outside counsel is to make sure that that individual or that firm understands our business, that they are creative, they're going to help to educate not only us as the plan sponsor, but potentially our employees also, and that they're going to work with us to ensure that they get buy-in from us. So those are some of the key things that I definitely will take away from our conversation today. And I thank you, Ann, and I thank you, Charlene, for sharing your knowledge and expertise with us today.
Thank you.
Thank you.